All right, Josh, I will hand it over to you and let you get started.
Great. Thank you, Sarah. Thanks everyone for showing up today for the webinar. As Sarah pointed out, we will be providing CLE to those of you who are interested. So why this topic? It's not a complex. It's not going to get into specific regression analyses or a specific case and tear into that. And the reason behind that is I'm a big believer in setting the foundation. If you can understand the foundation of any of these economic events, you can better service whoever it is you're trying to service. So I wanted to get back to some of those core principles. I do that because I'm either thankful or it depends on the day of the week, not thankful. I've had some instances this year where I've testified, provided expert analysis, and what I'm seeing out there made me think that we really do need to go back to our core principles and start understanding what it is as a forensic accountant, economic expert that we do today. As any of my presentations, right? And I say this post-COVID, where I live in a world now where I just look at PowerPoints and computer screens. If anyone has any questions, feel free to put those into the chat section. That will make this obviously more interesting. We only have an hour, so going to go through some concepts probably a little faster than some might realize. But again, if you have any questions, we can stop and go into details on those specific items. So what are economic damages? It's the monetary compensation for loss or injury measurable in financial terms. And there are many types of economic damages in the world. Those go from the types that we as accountants and individuals dealing with businesses talk about and lost profits. You also have wage claims where an individual could have a medical malpractice claim or a car accident and they've suffered lost earnings. Another aspect of economic damages is not just the cash that you take home in the form of profits or earnings, but diminished value. I'll go back to the car accident example. The car before the accident is more valuable than the car after the accident. Well, the same can be said for a business, right? And we'll go through some of those examples. Some other economic damages not talked about as much: increased costs, supplier relationships. How are increased costs impacting your earnings and the value? And then also the loss of use, not just the loss of use of a tangible asset. I think one of the best examples I've seen is you have a farm and you lost some of your cows that do the pulling. Well, think about it in a little bit more modern sense of loss of use of a workforce or a key worker, loss of use of a computer program. The point of economic damages is you want to put the person who has been harmed back into the same or similar financial position they would have been, but for the alleged action. And I say those last four terms, but for the alleged action, because as people who testify to these things, we have to understand that that assumption is in there. And for anyone who's doing an economic damage calculation, which is vastly different from litigating economic damages, you have to understand that assumption of but for the alleged event, what would have happened. But ultimately, we want to put the injured person or parties back into the position they would have been but for the alleged event. And that but for alleged event is what is coming from the attorney or the counsel that many financial experts are hired to work with. They're the ones who will talk about the case. And while we do mainly business loss profits, we do a lot of wage analysis. And I think wage analysis provides all of us here today with just a better example. Okay, so you'll hear me talk about that. But, it's very simple. Had the car not have hit me, what would I have earned in the job I had? Right? And so that's where, as the financial expert, you need to understand the facts of the case, the facts of the parties involved in the case, because there are these basic tenets which hold us to the ground of our foundation. And if we can put the facts associated with that, we can provide quantifiable, credible analysis. So in a business economic damage, what are some common scenarios? Breach of contract comes to mind, non-competes, which are a big issue of late. I feel like I'm reading about non-competes in the news more and more. You may also have a breach of a supplier contract, okay? Business interruption. A hurricane will hit Florida, and that will stop the business for a period of time. Well, maybe it's more than just the damage from the hurricane, too. Maybe there was a party who was supposed to supply your client or the company with something. So the point is your business has been closed for an action. Something that also is coming up more and more now is intellectual property infringement. Somebody taking a trademark, a brand, a novel idea, and utilizing that to themselves. And then also we see a lot of shareholder disputes. I would add on that in addition to the shareholder disputes that we are commonly seeing now, we see that in trust disputes, where you're calculating economic damages for the trust. Now, what's important is that as the accountant or the financial expert, right, in each of these scenarios, we need to tie some key metrics, okay? The 4 key metrics that I'm listing out here are the foundational key metrics. And step number 1, when performing one of these analyses, particularly in a business damage setting, is understanding revenue trends and cost structures, along with the market conditions, and finally mitigation efforts. So what am I talking about? Well, there's some basic questions you just need to ask yourself. And whether you're the individual or the parties who's been hurt by this, the attorney that's working with the party, and the accountant who's working on the case. What was the revenue trend? Okay. Historically, can we look and understand what the revenue trend? That's number 1 question that you would have. Was it going up and was it going down, or was it staying stagnant? And in addition to that, why was that business, the product or the service, acting that way in the current market or the economy it was operating in? Because it's very important when you present these analyses to explain to the trier of fact that your client or the business that you're measuring had increasing revenues in a depressed market. If you're asking for a revenue loss in a depressed market, you need to be able to explain that. And by going through that exercise, you're also going to uncover a lot of information which will be helpful for you in projecting those but-for lost profits. For example, do I have sound management? Well, if management can get you through a disruption, right, that will bolster the confidence in any of your projections. The next thing that you got to look at is the cost structure. Again, whenever I look at a cost structure, I want to understand that specific company, if the economy and the market it works in, okay? When I talk about market conditions, I'm talking about the economy as well as the industry, not separate and apart, but how those two interact with each other. But what were the cost structures? Going back to a patent infringement claim, was there a historical record of spend on research and development? How detailed are these records? What other information can you garner out of there historical revenue and cost records that is useful as it relates to the case. So those are the questions you need to be asking yourself, but you need to understand ultimately the growth rate historically and why that doesn't coincide with the historical market that we've learned about and how it relates to the case. And then when I talk about cost structure, right, what is the profit margin, the net profit margin, okay? And there's gross and net, but ultimately, what did I lose for those actions? The fourth thing, where you as an expert, regardless of working for a defense or plaintiff, need to do your own due diligence on is mitigation efforts. Because a lot of times you'll work for somebody who say, well, I couldn't have done that. And they give you your reasons. Remember, we are not in the trust business. Is the story being provided? And I don't care who you're being hired for, just save yourself the agony. But is the story that we are being provided, right? Does that make sense? Okay, I understand it. You lost a portion of your workforce. Why couldn't you hire somebody? Okay, I understand. Your machine was damaged. Couldn't you lease it? You start with those simple questions, and I'll tell you why. Because when you're in front of a trier of fact, the common sense question and answer is that's what everyone in that room is going to want to hear. So you as the expert don't need to overcomplicate that. You need to understand those foundations, because the follow-up question is where the real value comes out of it. Okay, you didn't replace it because it was too costly. Yeah, it was already at a thin profit margin. Well, let's understand why you were at a thin profit margin. Oh, well, management. So you want me to project you at a market of 10%, but historically you've only done 5% and you can see where that conversation can go a lot of different ways. And that is a healthy conversation to have with client and counsel. Don't let anyone tell you otherwise. It's not being disrespectful. It's doing your job to protect that. That's just on the business side. As a forensic accountant, we get the opportunity to work with individuals in economic damages. And that is personal injury, wrongful death, and employment disputes, right? And so the business can be damaged, but the employee can be damaged. I think it's interesting to work both of those cases and to get a real understanding in your arms around what our practice aids state, what our guidance and treatises talk about, and how those reconcile. But that's for a different date altogether. Again, key metrics. Obviously, historical tax returns when you're looking at wages is important. But what if the individual that was injured or there was a wrongful death didn't get a W-2? What if they received a K-1? What if they did get a W-2, but they also received some form of equity in the form of preferred stock, some sort of options? What if they're involved in some investment vehicle and there's carried interest? Right? And so what kind of wages, what kind of earnings and benefits? Getting the employment agreement, not just looking at a tax return, is where a CPA or somebody with a financial background may identify other tranches of benefits lost. Another metric is household services. So if I lose my left arm, and my wife may have a different sense of this, but if I was to lose my left arm, there's things around the house I do that I can't no longer do. Taking out the garbage, mowing the lawn, right? Going and doing the grocery shopping. I'm going to have to pay for somebody to go ahead and do all those types of things. An interesting standpoint on individual economic damages versus businesses, our life expectancy and what is our work life expectancy. So you as a financial expert, as a CPA or the attorney working on this, one of the things we need to know is at what age was our client? What was their overall general health? Do they have health records? What does it say about their life expectancy? And then lastly, fringe benefits. What fringe benefits did they receive? That comes into question quite a bit when you have a 100% owner of a business involved in some sort of personal injury. Employment disputes, particularly employment disputes with executives or individuals that are on some sort of commission or incentive comp, there always seems to be some fringe benefit that was offered to them. I think it's important. Again, this is about setting the foundation for economic damages. Today, what is important? Do I understand all the potential wages and benefits? It doesn't matter what side you sit on, you can still go through that. What is the impact of such and such loss, right? In terms of, yeah, I know the person or the individual went and worked, but what else did the individual do, right? And what did that mean for the benefit of their entire estate? And be very, and for those of you who are experts on the line right now listening, read how the case was pled. Who is pleading? Okay, is it the estate? Is it an individual? Things like that are important. So we do all this work, we calculate all these damages, right? And as I was saying, it's but for. And we'll get in later to the projections and the models that we utilize in doing this type of work. But at the core of what it is I have a washing machine business and it spits out 200 clean socks on a daily business. I get hit by a car. I get my work, half my workforce leaving because they took a sweetheart deal at the laundromat across town. I get because my business partner decided not to put money in for us to get the coin operator out there, whatever it may be, right? Historically, I did this. Now the question becomes, how am I doing now in comparison to historically? What was the cause or the reasonable cause of that? And what's the dollar difference, right? If I was doing 200 socks, but now I only do 50, that means I'm losing out on 150 socks a day. So what gives? That's the calculation. And the calculation, if you can go through all the financial metrics and the resources you need to look at, is easy. Presenting that can be the tricky part, because sometimes what I will see is people lack the experience, professionals lack the experience, they lack the know-how, they lack the understanding of the legal argument being made, how it's being made, what that means for me as an expert in terms of which hat it is I'm holding. At the core of it is this term reasonable certainty, okay? And there is, I've been testifying for nearly 10 years, but I've been in this business for over 20. And I consider myself somebody who tries to read everything to get an answer. I'm a big believer that our profession has a library of information that we should be utilizing. But guess what? There's no pure definition on what reasonable certainty is. There just isn't from my readings. I can't find it in a legal proceeding. I can't find it through the AICPA. So I go back to what I learned when I was at Royal Caribbean Cruise Lines, when my boss told me we're not in the trust business. So my standard of reasonable certainty, and I think it's worked in the courts, is I need something that I can hang my hat on, okay? So for me to project something, for me to assume something, and this is where reasonable certainty is important. It is okay to have assumptions. It is not okay to have assumptions that you are not reasonably certain about, okay? For example, if you're going to assume that a business can make a 50% margin, what is your basis for that? What can you hang your hat on is the question that you need to be asking yourself. If you can do that, then let's go through the bullet point. Damages must be proven with reasonable certainty, not speculation. How do I avoid speculation? I have industry research, I have an analysis, I have a schedule, I have a deposition transcript, I have something that supports whatever that assumption is. Courts require a logical and factual basis for the calculation of damages. I benefit from being a CPA that was once upon a time an auditor. So as an auditor, I have work paper standards. Everything ticks and ties. So if I read it that way, okay, it's pretty simple. Again, I'm not in the trust business. Here's my assumption. Here's the work paper that I support it with. Historical performance and industry benchmarks are often used to support projections. Yes, okay, so if I'm going to be reasonably certain and I'm dealing with a business, how does this business compare to other businesses? That's particularly important for those of us who do these types of calculations, but we also hold business valuation credentials. You're not going to have any sympathy if you get up on the stand and you, as a BV credential professional, sit here and say, yeah, I didn't perform an industry or a benchmark. I just took what management told me. And that's what the courts, I think, are trying to get us away from. I can only speculate what they're saying, but I get the feeling that they're asking me, the CPA, who is bound by my ethical standards, to come in here and say, yes, I can tick and tie this model, this projection going forward, and I feel relatively comfortable about what it is I'm presenting. Okay. One court case that you definitely comes up on this is Schoenfield versus Hilliard. The court emphasized that lost profits must be proven with reasonable certainty, especially for established businesses. That especially for established businesses is important because there's oftentimes where you'll see a projection of lost profits where it deviates so far from historical performance. You as the expert need to be able to explain that. Is there something in the economy or the industry, right? What is the secret sauce that is available? So that's reasonable certainty. I think that's the most important concept for those of us who opine on these to understand. And if you're trying to find somewhere that tells you what to do, I don't think you'll find it. How are you as a professional comfortable knowing whatever certification or license you follow? Yeah, I can with confidence say that I can check those off. Also in line with reasonable certainty is the concept of foreseeability, right? So you have to know that the damages must be a foreseeable result of the breach or wrongful act. I get hit by a car, I shatter my ankle. Me going in there and saying I can't type anymore, how do I connect that, right? I lost a key employee, but now I don't have a supplier, completely different department, right? And so what are we trying to do? If we were to just look at a business and go, okay, they traditionally made 200 socks a day, now they only make 50. Well, as you as an expert, do you have reasonable certainty? And then in that projection model, is there foreseeability that the injured party must show that the loss was within the contemplation of the party? So is there a connection between what is being pled, right, and what is being sought? And right there on the third bullet point, often evaluate at the time of contact formation or wrongdoing, right? And so to me, again, I'm not a lawyer, but I have to interpret these things. When I read that, what I'm hearing from it is, okay, this but for event, can I tie the but for to this alleged loss? A case that gets into that, right, is Hadley versus Baxendale, which ruled that for them to be recoverable, there needs to be the element of foreseeability. Causation. Causation is a big topic and issue. In a wrongful death or personal injury, causation is never an issue because you have a doctor or a medical professional that'll come in and we'll talk about the causation. And that causation then leads into or melds into foreseeability. But in a business damage dispute, there is often, many times, the expert is asked to state that the reason for the decline in revenue, the reason for the increase in costs is directly attributable to the defendant's actions. So whenever I take these cases on, day number one, when I am sitting with counsel and whoever is, am I a damages expert or am I a causation expert? Because to me, those are two entirely different work programs, for lack of a better term. Let's take a breach of contract in causation, right? I most likely need to do more work, right, that ties the specific revenues or costs related to that breach of contract, right? Now, am I going to have enough as a CPA to state that that's the ultimate reason for the loss in revenues? And I think that's where the conversation with counsel needs to be had is, look, going back to those metrics we talked about, I need to take a look at the market. I need to understand the competitive landscape, right? You need to hammer home on all of those factors. For anyone doing this work, and I don't get paid for this, but I always, since the first edition, have relied on Nancy Fannon's The Comprehensive Guide to Economic Damages. I think they're in their 7th edition now, okay? And if you go there, I think it's chapter 10, chapter 11, when we get into the different methods of it, or planning a credible loss profit analysis, there's a host of factors that the expert is supposed to look at. So if I'm asked to be a causation expert, I literally take those factors and I go through that with counsel. And I say, okay, I don't get carte blanche in discovery here right now. Yes, there's some things that I can do external research, but this is where, if I'm a causation expert, what time are you hiring me? Have depositions already taken place? Because I have some questions potentially in depositions, right? So it's almost assumed sometimes that as a business damage expert, you'll be speaking to causation. Be wary, speak with counsel, show them the factors, right, in a business that we have to go over. I think I might have a slide on this that speaks about that, but you have to look at the market conditions. You have to look at the general overall economy. You need to look at the competitive landscape. You need to look at the assets of the business. It's very much the same types of things that we look at when we're doing a valuation for Rev Ruling 59-60. And as a causation expert, you need to be prepared to speak to those, whether in written or oral testimony, okay? So, am I a damages expert or am I speaking to causation? And listen, I had a case earlier this year. Normally, I think I would have had to speak to causation, but guess what? Liability had already been admitted. I've had other cases where, depending on where my role is, because liability is first and then damages, that can cause some changes in the numbers and the way the trier of fact looks at it. Probably the biggest case on this that I can find is Bigelow versus RKO Radio Pictures. Reasonable estimate, okay? So this is a good case in the fact that I don't need to be to the penny, but I need to be reasonable. That's why it's okay to round dollars. I see a lot of people in damages particularly, they're so against rounding. Well, it's a forward-looking projection. Why do we have to put this thing to the penny? That's just, no one's got the crystal ball, is what I would say. So, as I'm doing my damages work, just going back here real quick, reasonable certainty, causation, foreseeability. These are all part of the engagement planning that I'm looking at. And then ultimately, just because I know it's going to be front and center, right? How is the plaintiff mitigating their damages? And that's the best part of the story. You know, one of the, I don't know if it's a benefit, but one of the things that intrigues me is the story, right? The litigated matter of what's going on. My role is just to measure a portion of that story. So, you know, part of that story is, yeah, obviously the events that led up to the but for, but what's happened since then? And the what's happened since then, I feel like sometimes can highlight a lot of these litigations. But what do we know from our tests, the text and the treaties that I prescribe to? Plaintiffs must take reasonable steps to reduce their losses. Anytime I see pronouns or adjectives for my financial testifiers out there listening in on that, identify a pronoun and adjective, ask counsel to define that for you, okay? Failure to mitigate can reduce or eliminate recoverable damages. Speak with counsel up front about this. What are they doing to mitigate? They're not mitigating? Why, right? Experts can assess whether mitigation efforts were adequate. So back into causation. Can a part of my testimony talk about the adequacy or the inadequacy of mitigation efforts? Yes, it can get into that. That's where the facts dictate, but we still have the pillars of our foundation. You got to document what sort of documentation. You know, say your client is suing somebody for improper termination, and you know, did you go out and try and find new jobs? Yeah, I did. Okay, can you show me? No. So now we get into credibility. And remember, the last thing you want to, you know, and I tell attorneys this, I understand my role in the litigation. And one of the best things is that I am seen as credible and non-biased. So attorneys, why would you ever want me to be in a situation that I came across from that? That's like me as your sharpest knife and you just dulled me. So that's how you handle that discussion with them. But speaking on mitigation, there's a lot of points in understanding the story, particularly your projections, that mitigation needs to be addressed wholeheartedly, and that is fact specific. So how do we calculate the different things? Well, on the business side, there's 4 methods: before and after, yardstick, sales projection, and market model. 70–80% of the work that you'll see out there will utilize a before and after method. On the individual side, right, if they're a W-2 earner, they have a contract, it becomes very easy. Where it doesn't become easy and where you might need a vocational expert is somebody who is underemployed, somebody who is in a field that might be evolving. Also, think about an individual that was a business owner. You have to first think about what was their role within the business, i.e. personal goodwill. It's not just in divorce, right? But then, do I utilize a business damage method in that individual calculation? So that's where, if you're a sound expert, you're going to know all the tenets that we're talking about today, and then how to use those levers based upon the specifics of your case. When you try and get innovative or get creative, but you're not reconciling with these tenets, that's where I can see people get themselves into trouble. I also see themselves get into trouble when they can't speak to just simply, these are the models I looked at and assessed. Why did you select that one? Okay, answer that question. Can you answer reasonable certainty, foreseeability, and causation? Just answer it. And if you can answer those four things, what are you nervous about? So let's get into this. Before and after method, simply comparing financial performance before to what happened after. All right. Very good to use when you have a stable business with that type of history. I'm going to kind of speed these along. If anyone wants specifics on that, happy to do it. But as I'm watching time here, I got some slides I want to get through. The limitations, it requires a stable and comparable pre-event period. Now, how long is that period? Two, a business life cycle is usually 5 years. Also, the damage periods that I'm starting to see, believe it or not, are right around 2021. We're still kind of in that COVID. So how much was COVID involved into that? So not only the length of the damage period, but the actual period and what was happening in the economy can be important. It may not be good historical data because for 2 years they were impacted negatively by COVID. So those are things you have to consider, right? The strengths, it's simple. It's very digestible for anyone. Remember, and I know this is hard, we as experts want to be the smartest person in the room. That's not our job. Our job is we're really a walking, talking calculator that takes the facts and applies it into models and tells the trier of fact why it does or does not work. Okay? Anything else, you're getting outside your line. Yardstick yardstick method. That's when, that's the Zillow approach. It's a market approach and evaluation standpoint, right? This is helpful when when your plaintiff lacks sufficient operating history or when it's a new business. Now, if you do have a lack of history or new business, the question becomes, and I've actually written an article about lost profits for new business startups. There is a different methodology that gets into management's prowess and acumen. Sufficiency of working capital. Yes, it's great that you think you're going to be, up there with the top 5 HVAC distributors in Southeast Georgia, but you don't even have enough capital to buy a tenth of it, right? And so those types of questions, again, how comparable is my company? A lot of the times you don't have sufficient data because it's a startup. So can I explain to the trier of fact that they were even going to be in the situation because they have certain financial or qualitative components that go into it? Okay. That's the yardstick method. Sales projection method, which I've utilized these 3 methods. Sales projection method is a great method if you got the right evidence. You can't have sales forecasts that were done, just because we were thinking about going into business with so-and-so, or, yeah, we just started this idea. Was the forecast presented to the bank? Did they accept it? How often are these forecasts going out? Think about it in a situation where you're a purchaser and you may have bought something and it didn't come to fruition. Well, if they were providing you forecasts, who provided the forecast? How many forecasts? In each of these different methods, and that's why before and after is the simplest. You're relying on, look, this is what happened. This is how they were happening up to that event. Now I get into the market method. I'm getting a little into what I think that could happen, but you don't have historical data. And that's hard for a jury or a judge to say, you're telling me that this idea is going to be a $5 or $50 million business. How is that possible? I'm not saying that it's not accomplishable, but you as the expert need to be able to one who can help everyone in that courtroom cross that bridge. The market model method. This is somewhat hybrid in that you're taking regression analysis, okay, and you're applying it with some market data. I'm seeing this market method model utilized mainly with intangible assets because, again, how can I take a variable like consumer appetite and connect that to a financial outcome? All right. And right then and there, that's the strength. So in a lot of these IP infringements or, yeah, you know what, even in what I would say these non-compete works, that you can specifically isolate that variable, and with a regression analysis, it's easy to showcase this. Sometimes the model is dependent upon who is the decider and the trier, and what is easy for them to digest. There's going to be a litany of facts related to the case that is coming in. How can I make my model, that story, digestible? And that's the skill of an expert. Just another court case where the yardstick was utilized. So how do we do this as a profession? Well, the first question is we got to do planning. Just like when our cohorts are planning an audit or they're planning a tax engagement, we need to plan for this credible loss profit analysis. And what we've gone over today is probably some list of things that should be in the back of your mind. Whether you're the attorney, whether you're the business owner online today wondering, do I have a potential claim? Do I need to call Dean Dorton or a law firm? Okay. Besides reasonable certainty, foreseeability, and causation, do I know the period of loss? Okay. What loss period are we talking about? And I think that's important for the attorney, because a lot of times you'll have a business owner come in and they may say that they're experiencing losses, and they might do, but the contract might only get you 2 years of losses. And so if you went and you just did the math, let's say that those losses, you know, and emotions sound a lot more than what they're really worth. Let's say that those losses are 150,000. Well, how much are fees going to cost, right? And so that cost comparison analysis, taking into consider the costs and also the time, is something that needs to be understood. So what's the period of loss? And then if this is something that has happened historically, how long did it go on for? And what were the implications? What data do I have? Again, I'm not in the trust business. So I sit down, I hear the story, I read the complaint, I get all this story. Show me something. Show me a tax return. Show me a financial projection. I love working with larger companies when I can sit down there and I can talk to the AP manager, or I can get in there with the controller, because they might have some operational data that helps tell the story. All right. So you wanted to, you have a claim for, you know, economic damages because you wanted to open a restaurant during COVID. How does that play into the, you know, so what is the market conditions? A lot of people have great ideas, but then they don't look at what the competition is out there. And so my point on that is, you may think that you are able to go to market, but you're not. Okay, capacity restraints is what I was talking about before. Yes, maybe you could have sold 100 million widgets, but guess what? Without a bank loan, and oh, by the way, your credit score is below 500, it's never going to happen. And so, you know, that's that causation, foreseeability. Yeah, it's foreseeable, but in order to get to there, you would need the bank loan, you would need whatever, right? And then lastly, well, actually, document your assumptions. Don't be afraid of your assumptions, especially if they're reasonable, okay? But every expert, you're doing a forward-looking projection. Of course, there are assumptions. Are they reasonable? And just put those out in front. You do not need to hide behind those. And let the attorneys know what they are, because it is what it is at the end of the day. And then perform a sensitivity analysis. And how do you do that? You know, here at Dean Dorton, I'm lucky enough that I have several partners and team members that I can have read my report or look at my model and just go, that doesn't make sense to me. But another thing, Artificial intelligence is a really great tool that I'm starting to see used in a lot of different ways. Run a different model. Take that variable, right, and do a high, medium, low assessment. Is your boundaries, your high to low boundaries, make sense? If they are materially different, why? And it's important in testimony to talk about your planning analysis. That's what shows why you're not biased, why you are credible. And credibility is about experience in handling such situation. Okay, and more so ever than in this case, where you got to use reliable data and assumptions. You can't just take what's given you to you. I've seen it too many times. It's happened to me earlier in my career. Well, this is all that's available, Josh. Oh, well, you're the forensic accountant. You got to figure it out. Yes and no. I'll try my hardest, but not going to lie on the sword to ruin my career. So what are the common pitfalls? Overstating or understating lost profits. That happens because you don't understand the gross profit, the true revenues and the costs associated with it. And that overstatement or understatement can happen many times throughout the litigation process. Ignoring what's happening out there in the industry and the market. Okay. If you're the one who has a damage claim and you are ignoring that, you're ignoring reality. And that goes not just for businesses, but for individual earnings. Using flawed assumptions. And this goes back to, why do I want to do a sensitivity analysis? If counsel or the client or something or someone is pushing you on a certain assumption, right? And you can feel it, either you're sweaty, you're nervous about having to speak to it, which is a trigger event, right? Show that you have to show the upper and lower boundaries of that. Okay. And so that's the first thing I'm looking at in any rebuttal that I'm doing is, what were their assumptions? How transparent were they with those assumptions? Are they trying to hide the boat? If so, why? And then also failure to consider mitigation or alternative causes. I see this a lot. People just want to do things by the textbook. They do not understand the full economic reality of what is happening. I mean, if someone goes out there and there's a damaged business and they start a new business, you have to understand the entire economic reality. The guidance that we get from our texts and aids, they tell bits and pieces. It's our job as the expert to take those tools and put them together. So, having said that, I have about 5-10 minutes left. Do we have any questions at this point in time? If not, I'm just going to kind of go quickly here through the case studies. Honestly, the case studies, we probably could have had a separate webinar completely on each one of these with a little bit more detail. But what are some things we see here at Dean Dorton? COVID-19 business interruptions. I would throw hurricanes into that because of our operations in Florida, right? So our but-for modeling using historical statement, right? This is an area that we've been involved in. And you can say the challenges, courts required clear causation and documentation, particularly with COVID. Another issue that comes up is wrongful termination. I think the challenge in a wrongful termination is that damage period. How long do we project those losses to go on, and why? That's where it's important to recognize, if you're being asked in a lost profit situation to carry the weight of the labor market studies, it might be outside your bailiwick. You need somebody who's got that vocational background or expertise. Just a restaurant chain being closed, right? Forced closure, we have a COVID, right? Maybe it's because of a rental agreement, a lease agreement, whatever, right? Mitigation, they adjusted for their saved labor and food costs. How are you taking those things into account? So that's a situation that comes up. And then seasonal disruption brought on by something that happened earlier this year. You haven't seen any reports on it. It's the tariffs or the Doge event. Doge impacted a lot from USAID. We got calls from people saying that their contracts have been suspended, right? There's a lot of different types of disruption. Tariff, right? What is that going to do? So a lot of the events that we're reading right now, these current events, me and my team, we see them 12, 18, 24 months into the future. For the financial experts that are on the call, there are some legal considerations that you need to be wary of. Differences in the jurisdiction. Always, if you're working, and I don't care if that's the difference between working in Jacksonville, Florida and Cincinnati, Ohio, or Jacksonville, Florida to Orlando, Florida. There are differences in in the jurisdictions. There are differences through the history of those courts. Ask counsel to tell you about those. If counsel's not aware of them, did we pull anything from Nexus Lexis in this jurisdiction within front of this judge? Be aware of Daubert standards, okay? The legal consideration of a duty to mitigate, that is a legal consideration. That is not your consideration. Speak with counsel about that. And then the responsibility in documentation and discovery. Those legal considerations. Yes, you asked me to do a report. Am I able to do that considering where you're at in the discovery process? The expert witness roles, independent, objective analysis. I get it. My clients, it's weird. You got to pay me a good amount of money and you may not like what I have to say. So what are you paying me for? My credibility, my independence and objectivity. Hopefully you have a real good feeling about your case. That's why I want to have this discussion ahead of time before we jump into a full-on contract is, let's go through some of these tenets and understand where you're at your case. I do a lot of that, just what I call pre-suit consultation on these types of things. My job is to prepare an expert report and any rebuttals, testify, and help attorneys understand the complexity of certain financial issues. But ultimately, right, independent, objective analysis. What are my lessons learned and doing this work over all these years? Collaborate with counsel early. Yes, people get worried about, am I going to sign you on all that? Take an hour. You and counsel sit down. Yes, counsel's interviewing you. Interview counsel as well, too. It's helpful for the client. What are we at? Can we get this done, etc. Hopefully this isn't new. Use reliable data sources, not just what your client tells you. Document your assumptions and the methods. Being able to explain what you did. Juries and judges are okay hearing that you ran into an issue, and they like hearing how you solve that issue independently. Okay? And then prepare. We have some time here for a little bit of Q&A, but we went through a lot. Hopefully this was just a very good primer and overall of what it is we do. I'm sure everyone may have more and more questions. Feel free to reach out to me. You can find me at jshilts@deandorton.com, or feel free to inquire by going on to our website. I want to thank everyone for their time today. And please be on the lookout for future webinars from our Forensic and Valuation Services Department.